Is it possible to save one's case if they already received a notice of intent to deny? I'm going to share a story with you of one of our clients. Obviously, I will not tell you the client's name, but I will describe the situation where we were able to save that client's case. It was a VAWA case, Violence Against Women Act. Case was filed by client in 2020. Priority date on the case was 2015, related to previously filed I-130 that did not result in an approval. In 2020, client found some paralegal working in the Bronx who graciously offered the services to the client along with tax filing. Of course, it was a mistake to hire that person because they did not know what they were doing. Maybe they've heard something online or they had one successful case and they decided to take such an important and complex case as VAWA. They wrongfully filed adjustment of status for this client together with I-360 form because the client had previous order of removal, which of course was never checked by this paralegal, and they started waiting as to what is about to happen. 2 years passed and they did not have any answer. At this point, client realized that something was going wrong and they contacted my office. In VAWA cases, it's possible to add evidence to the case at any point in time, and this is what we proposed to do for this client. In 2022, to move the case along, advised the client to collect additional evidence of real marriage and abuse and submitted that evidence to Vermont Service Center. Again, for almost 7 months, we did not hear anything back until we received notice of intent to deny. Of course, it was devastating, and notice revealed that the paralegal who was working on the case committed multiple mistakes, which now were highlighted in the notice, and the client was not even aware of. Now we had to have a creative strategy as to how to address those mistakes, plus strengthen the client case. We sat down with the client, helped the client to draft a very detailed affidavit explaining why things went wrong, why the information was provided incorrectly, and what truly happened between the client and the abusive spouse. We also were able to advise and collect additional evidence that strengthened the client case, and most importantly, I personally drafted a very thorough memorandum explaining how this client qualifies for VAWA. And guess what happened next? In less than a month, the client's case was approved.